Good morning, everyone. Welcome to another edition of the WILMIC Summer Seminar. This year, of course, we are all virtual due to the coronavirus pandemic. We have almost 250 of you out there online, and so we appreciate you joining us today. We have a terrific program for you. We will, as usual, go about 3 hours. We have two different 75-minute segments for you. The first segment will be on family law issues, and the second half will focus on estate planning issues. Milwaukee attorney Greg Herman will cover the family law issues, and Madison attorney Bill Williams will cover all the estate planning issues that we want to cover today. Just a couple of reminders for you. There is a text box on your screen where you can type in a question or a comment and click on Ask the Speaker. That will send your question or comment to us. We will have the speakers address those for you when they have the opportunity to do so. Also, I will remind you that this program has been approved for 3 ethics credits by the Board of Bar Examiners. Also, if you want to access the written materials during the program, you can do so. There is a handouts tab on your screen, and that will give you access to all the written materials. One note that I want to let you know about, we occasionally will have some video glitches. Our first speaker, Greg Herman's feed is freezing just for a second or two on occasion. If that happens, it's on our end, it's not on yours. If we can do anything to fix that, we will, but I just wanted you to be aware of that. So I think that's it. Again, thank you very much for attending today virtually. If there are any questions regarding the program at all, don't hesitate to either send that to the Ask Your Speaker tab and I will get it, or you can email me at tom.watson@wilmic.com. My name is Tom Watson. I'm Senior Vice President at Wisconsin Lawyers Mutual Insurance Company. And again, we thank you very much for participating in our summer seminar this year. So let's get started. Our first half of the program is, as I said, about family law issues. Milwaukee attorney Greg Herman is going to talk about the substantive issues of family law in this COVID era, support orders, mediation, communicating with clients, all those challenging things that have become more challenging during the pandemic, practicing law in the COVID era, what's different about it, and where do we go from here? So Greg will cover all of that. Greg is a shareholder with the law firm of Loeb and Herman in Milwaukee. He practices exclusively family law. His first job out of law school in 1977 was with the Milwaukee County District Attorney's Office as an assistant DA. He worked there until 1984 when he joined Leonard Loeb to form the Loeb and Herman firm, where Greg is now the managing partner. Greg is also a certified mediator. So with that, I would like to welcome attorney Greg Herman to the program. Good morning, Greg.
Thanks, Tom. And good morning, everyone, and welcome to the program. When Tom first asked me to do this, it was sometime in June, and I had just a Zoom call with a bunch of family law attorney friends from around the country. We have sort of an informal friendship group, and about 20 of us were on the Zoom call and just going around about what's going on in our jurisdictions. And finally got around to me and somebody said, "So Greg, what's going on in Milwaukee?" And I said, it's just been a normal summer so far. We've had a pandemic, which has totally shut down our legal system, and for that matter, shut down virtually our entire economy. We have mass demonstrations going on with some rioting and looting. And oh, by the way, there's a hurricane headed our way this weekend for the second time in recorded history. It's just a totally normal summer. Well, since June, fortunately, the hurricane was mostly a non-event. The demonstrations continue in a much smaller manner, but fortunately, unlike certain other cities, we don't have the rioting and looting. And to some extent, the economy is reopened. So what we're left with then is just the partial shutdown of the partial. And what I'm going to talk about today is some of the on our family law system and what's going on. One thing I feel really bad about, and I sort of apologize for, I hate beginning a speech with an apology, but normally when I give a presentation, or for that matter, when I talk to clients and identify problems, I like to also suggest solutions. And I'm on the unfortunate position, as I'm sure will surprise no one, but the unfortunate position of having to be able to or problems, potential solutions for. So, I think we're in the position where having a number of doctors in my family, I understand that the protocol for when there are issues and problems and that you don't have a cure for is to treat the symptoms and hopefully that the disease remedies itself in some fashions or at least becomes livable. And I think that's the situation we're in here. Until somebody invents a vaccine and everybody gets a shot and this whole thing goes away, or there's some form of herd immunity, and seems to be happening real soon, we're on the position of having to treat symptoms and manage the situation and hope that over time things remedy itself. And I want to discuss it from several different perspectives. I think the most important one, of course, is how it affects children. So I want to discuss, obviously, the effect of what's going on custody and placement issues and what some of those issues and problems are, and some ways in which I understand it's being addressed and dealt with by the court systems and by attorneys. Support is a major issue given the employment situation that's going on, and I want to discuss the legal aspects of that, and then in terms of how it affects negotiations. I do point perhaps hopefully things that may come be a positive person, and I like to find something good even in bad situations. And then finally, and this is really a hook to keep you listening until the end of the presentation, is to try to take a look at the crystal ball and see what the future might have in terms of how this thing plays out. So with that as the general outline, let me start with what is the most important aspect of it, I think, which is the issues regarding custody that are affected by this pandemic. And there are a number of different issues that arise here. I do want to thank, and I put in my outline, but do it verbally as well, Attorney Lisa Bangert, who's one of several attorneys who assisted me in terms of giving me a broader perspective in terms of some of these issues, and both in terms of what pricing and also in terms of dealing with it. And I've listed a number of issues, but there are three primary ones that I think are the ones that are the most common and most serious ones to deal with. And the first one deals with the issue in terms of the placement schedules and how those are affected by the feelings of many parents that the other parent either isn't doing a good enough job in terms of protecting their children, or that the placement schedule in itself is dangerous to parents. And I've heard this a number of times from my clients, former clients, from it arises in any number of aspects, in particularly in terms of where one parent thinks is not socially distancing the children. And there are as many differences of opinion probably as there are people out there, the severity of this and what sort of measures have to be taken. There seems to be a general consensus developing in terms of the necessity of mass social distancing, washing hands and all of that, but it certainly isn't universal. And the first issue in terms of anything you think of in terms of litigation, of course, is a proof issue. I did hear of one case where one of the parents was putting on Facebook pictures of the kids playing with other distancing, but that's anecdotal. And for the most part, being able to allege that the other parent is being safe to children, the issue in terms of trying to prove that. And I'm not even going to deal with the issue at this point in terms of even getting that into court, which is a whole separate issue entirely. The issue that's involved in, there's no, as I said, no clear consensus as to how much safety, in terms of how much do we want to keep our children in a bubble. As parents, we all want to keep our children safe, but in terms of the necessity, how you're faced with the old issue that we have in placement issues all the time, which is, okay, so if the children aren't being protected to this degree, how much does it change in the placement schedule remedy that? And you don't schedule, at least in most cases, where one parent's barred the child. So what's the difference? What's the experiential difference? What's the numerical difference in terms of the parent gets less time, but still can expose the child? And that's even assuming two major assumptions in this. The first is that it's provable, which absent something on Facebook or some other means of doing so, the only proof may be the children. And generally, we do not want children having to serve as witnesses and having to the other parent. And then, of course, the other court at all, even if you do have proof, and I'll discuss that later, but it's a huge problem because it just it's never been easy to get in court with that, and certainly isn't has gotten worse. Now, these problems have all sorts of other difficulties in certain cases that arise. Certainly, when you're dealing with extended parent, perhaps not socially distancing the children, but if there's a blended family, say on the other side, and then there are stepchildren coming over, and the other parent of the stepchildren isn't doing what the first parent is, you need an app for this. You got to try to figure it out. It just becomes mind-boggling. Someone suggested to me that I hadn't even thought of this in terms of parents making computers available, having applied connections. Tom mentioned earlier that sometimes our system here, which we are high wired with high speed, and even that sometimes checks out. I know of a family that has 7 children at home, and somebody's always getting knocked off the internet, and they have high speed and always handle that amount of traffic, and it brings up all sorts of problems. What I have heard of anecdotally, seen a little bit with my own experience in terms of what courts are doing with this mostly is to serve as just a warning to parents, more giving people a lecture, giving people a reminding them of what the 3 W's are: wash your hands, wear a face mask, watch your distance, but not making any changes in the orders themselves. And I think that's going to be fairly consistent with what courts are going to do with this. A, they always want to discourage litigation, but B, the proof is going to be so difficult, and the remedies are not totally clear in this in terms of what I said, changing a placement schedule from say, 9-5 or 8-6 or even 10-4 doesn't really answer the problem, because if the issue is exposure to the virus, that can happen even on a minimal placement schedule. So none of the proposed remedies, other than to completely cut a parent out until this issue resolves itself, which is at an unknown time in the future, are particularly palatable remedies. And where the court doesn't have a palatable remedy that's immediately available, and again, heard anecdotally, are pretty much just to leave things alone and say, look, this is the situation. I don't have a particularly a cure for this right now, and lecture both parents just to do the right thing and hope for the best. Substantially increasing anxiety levels of the parents, which then is reflected on the children. But then again, all of our anxiety levels are increased. It's just one of the natural ramifications and things that happen as a result of having to deal with this pandemic. One of the most difficult difficult is arising here, and I expect is coming up now with more frequency, is going to be the custodial decision regarding schooling. It's always been the most likely issue of the joint legal custody defined issues in the statute, the most likely one to be litigated. The statute defines 6 areas in joint decision-making, and I've never heard of anyone argue about whether a child could join the military, get married, or drive a motor. The other 3 are also relatively rare. And the most likely one to be litigated is over choice of schooling, which is generally remedied by what school district the child lives in. But it can be one in a few of those passed. Now we have different level into this because the decision-making is no longer what school the child, how the child will attend the school. And every school district is own way of dealing with this. There's some school districts that are entirely in person, or going to be. There's some that are going to be entirely virtual. And then I have a 9-year-old grandson, and let me just parenthetically say, we get a bunch of those little critter grandchildren, and it's a whole lot easier being a grandparent in these circumstances. I should mention it's always easier being a grandparent. There's nothing more fun in this world in my experience, but this is an instance where it really, how much easier it is to be a grandparent, because we don't have to make that decision, and I'm glad we don't. And at least for his school, the school system came out with a compromise. And this sounds like there were a bunch of divorce lawyers negotiating this. Their compromise is that half the students go to school Monday and Tuesday. Wednesday, the school is closed for both Thursday and Friday. And during the 2 days that you're not in school, you're supposed to learn virtually. And boy, if that doesn't sound like a committee making the decision, I don't know what is. I'm guessing it's probably going to make nobody happy, because if you believe that any exposure, if you're part of what I call the bubble mentality, that you want to keep your children in a bubble and completely protect them from potential harm, 2 days a week isn't going to do that. And if you're of the other school of thought, which is socialization for children is important, and that the risk can be minimized because either because children don't seem as frequently, or when they do, as bad a case of the virus, and the socialization and the learning for the children is important, then only going 2 days a week as opposed to 5 isn't that helpful. And then finally, of course, there are children that are much better than others at getting on the computer virtually and paying attention. And there's some children that wouldn't do that at all. And then you worry about what the ramifications are, assuming this whole thing resolves itself within the year, and there's no guarantee that it will, in terms of what happens next year. And I feel sorry for the teachers doing this. And then, of course, we have the risk of what I call the stutter start, which is they start school and there is a disease, and then it has to end, and they have to redo everything to begin with, as if it never happened. And that isn't just children getting sick. A neighbor of mine who's a school teacher says that the biggest fear in her school system is that the teachers get sick, and good luck finding some. It's the former substitute teacher, and she never really enjoyed that. She did it for a number of years, and she said there's just absolutely no way she would go into a strange school system on a substitute basis now, having no idea what cleaning they're doing and how they're socially distancing children, and teachers getting sick, and then you have to go back to square one, and hopefully the school has made backup arrangements, has a plan B. In terms of the legal determination of it, in almost every case we have these days, it's called joint legal custody, whether it's meaningful or not. Of course, most people think that has to do with placement. We as lawyers know it doesn't. It has to do only with decision making. But I want to point out something here, which is there's a misconception among most people out there, and also among some courts, as to what joint legal custody really means. The misconception, and this I have found not just in people that are going through or have been divorced or have not been married and have paternity placement and custody issues, but also with courts. In fact, even in one court of appeals decision, custody means that discuss major decisions and come to a joint agreement. It makes sense. When you say joint legal custody, it certainly sounds like that's what it requires. But there is a statute here, and I'm actually bringing my statute book with me here and actually read it, because that's not what the statute says as I read it. And so I don't have to worry about paraphrasing, and I'll read directly from 767 point, I believe it's 001, can't get a better number than that, S, and I'll read it exactly. It says, joint legal custody means the condition under which both parties share legal custody. Boy, thanks a lot for that. That helps, huh? And here's the key: neither party's legal custody rights are superior except with respect to specified decisions set forth by the court or the parties. So unless the court specifies a decision as being allowed to be made by one parent solely, or the parties agree, then the parties share legal custody and neither party's rights are superior. What I think that statute means is not that the parties have to discuss it, because it doesn't say that, and it's nowhere required, or that the parties have to agree, but that both parties have individual rights. If you want to look at it in terms of the legal phrase joint and several, it's really several, not joint. Each party have individual rights, and one has no more rights than the other. So the result is, in theory, one party can register a child for in-person and the other for virtual, and of course, the child can't do both. The legal ramification, of course, is that a court faced with that sort of situation would have to award one parent decision-making in that specified area. Courts don't decide where a child goes to school, and they don't decide what type of learning the child has. What a court can do is authorize one parent as opposed to the other to make that decision. But again, that requires the fact that parties are able to actually get into court on this, which is by no means guaranteed. I'm going to guess that this is going to be the area of the most dispute, the most argument, and perhaps even the most litigation on it. I hope not. I hope parents will find a mediator in this. And my suggestion, and what I have told people and clients where they've come up with this, is that the mediator in this situation should not necessarily be an attorney. A certified mediator, I do a fair amount. I find as my hair gets less black and more gray, I'm called upon to do more mediation. I'm just jealous I have any hair to talk about at all, but I'm pleased about that. But this is an area that's not really a legal determination. In terms of a particular child, if they're able to get online and be able to get as much learning if they're in person or not, and what the other options and alternatives are, it's a good area for a mediator trained in child issues, somebody with perhaps a social work degree, called a child specialist, psychologist, who has training in terms of child issues, or somebody who has training in terms of child education to be able to talk to the parties and be able to come to some sort of resolution. The third major area that I want to touch on here is one that's probably the most concern, and I don't have any answers on this one either, but deals with the safety of the children. There's been a lot of reporting the possibility of children being subject to more physical and verbal abuse home where two parents are and have a limited amount of ability to get away from each other, and to the extent that increases tension in the home, fighting, and things to which the children will be subject. I have no doubt that when all this is over, they're going to come out. It's going to be are going to be studies that, and I'll tell you right now that I'll bet dollars to donuts, as the saying goes, that they're going to find that there's an increased amount of stress on children, increased amount of verbal and physical abuse. I don't mean to denigrate those studies. I find that in a lot of studies, there's a great deal of what's called confirmation bias, that the studies are done by organizations of people that want to end up making those. And it may very well be true, I don't know. But the part of it that worries me the most is the part about reporting, because a lot of child abuse is reported by teachers and by the school system. And I've been involved in cases, including one where a teacher put his arm around the child screamed because there were marks on his back and being whipped by his stepfather. I don't mean just to choose an anecdote as meaning it happens in all cases, but I think that something teachers are trained in, school social workers are trained in. They're, of course, mandatory reporters. And without children going to school, I think there's going to be an issue in terms of the reporting. So those issues in terms of the children, I think, are really the key ones in terms of what risks are out there and what those legal issues are. I'm going to touch on a few of the other ones just briefly, but they fall in the same category as issues and problems without any on these. That is certainly going to be coming up in the future when travel is allowed again. To what extent is the issue going to be arising that travel in itself is dangerous to children, getting on an airplane, going through airports? They're cleaned beyond imagine, and nobody knows in terms of what the issues would be. And we always get the issues where one parent wants to take a child and vacate other parent's placement schedule. This, I believe, is going to be an even more severe one in terms of what happens when one parent says the place that the other parent wants to take a child to is inherently dangerous, or the travel itself is. The issue of events that children might go to is also going to be a difficult one. My two older grandchildren who are very social, love their friends, miss them terribly. One of them was invited to a birthday party, the 5-year-old, and the parent promised that they're going to have the children, but they're going to keep the children apart to be able to see and talk to each other. Well, can you imagine a number of 5-year-olds and trying to keep them apart? It didn't work real well. It didn't last very long. And eventually everybody just gave up even trying, because it just wasn't going to happen. And that's going to be an issue that's come up here as well. And then the issue of what happens when a parent or a family member of the other side tests positive or is exposed to somebody who tests positive. The testing numbers that I see right now show that they're staying steady, some places even increasing. And what do you do in those? The protocol is self-isolate for 14 days. Well, if the kids are with you, does that mean out for 14 days, which is going to make them happy? The St. Louis Cardinal baseball team ever got out of the Pfister Hotel. Last I heard, they came to Milwaukee to play a series with the Brewers. A number of members tested positive, and they locked up the entire team. Apparently, they let the non-positive testing players leave. I presume the rest of them are back in St. Louis as opposed to still locked up in the Pfister. I can't tell, but that's one thing to do with baseball players at the Pfister Hotel, something else to do with parents. And there again is no really good answer to this, something that parents have to attorneys. All we can tell the parents is to do the right thing, and that the starting point, of course, is that there is an order in place. And while there's an order in place, that they should follow the order unless the danger on the other side is so inherently difficult and insurmountable that there really becomes no choice. So I don't know quite where that plays out. I would suspect that it's easy if the parent on the other side does test positive to say, you know what, I'm going to keep the child here and see if there are any symptoms. 2 weeks isn't going to hurt you or hurt the child. The more difficult is if the other parent is exposed to somebody who tests positive. Any firm evidence of this, I'm going to guess it depends on the degree of relationship and the degree of connection in which the positive is more or less likely to come in touch with the child. So these are difficult issues. And again, I apologize for not having real solutions to it. My suggestions and all I can think of in terms of treating it is, first of all, where there isn't going to say that the parents should follow the order, continue with the order, not because it's any particular solution, but nobody seems to have a better one. And unless it's inherently dangerous to the child, basically continue with the status quo, do the right things in terms of the 3 W's. The area of support is one that I've been involved in quite a bit since the first couple of weeks. I received a number of calls, some from payor former clients of mine, a couple from payee former clients of mine, in terms of the loss of jobs. And it's so odd about this whole thing is how fast things have changed, but how fast things have changed is such. Just for fun of it, I read a monthly column for the Wisconsin Law Journal, which is basically for areas of family law and my opinions on it. Welcome feedback if you want to read it. It's at lobherman.com. So if you're ever interested in my opinions and my rantings. A few months ago, before the epidemic, I wrote an article. Interesting it is in going to court on issues of choice of employment that things are at the such a low employment rate that going into court and saying, I can't find a job is not going to find very sympathetic ears in the court. I've been doing this for a long time. Appreciate Tom not giving the exact years of my joining Leonard Loeb in a while. So I've been through quite a few recessions, and I've been through recessions where people have lost their jobs, and you go into court and you have to do this double step about getting relief from the order. And then when the person finds a new job, and they're usually in a job search, coming back and resetting support. And that's gone on from time to time, and is a big deal. 6 months ago, for that matter, maybe even 4 months ago, was jobs were plentiful. Our unemployment rate was 2 to 3%, which is about as close to full employment as you're ever going to find. And probably that 2 or 3% was transitional. So going to court and claiming, I can't find a job at all, you're not going to get a lot of sympathetic ears in the courts. It's like, yeah, really? Well, you're not looking real hard. The past we've had recessions and people have been laid off. There's this sort of gradual thing where, okay, get layoffs here and layoffs here and layoffs there, and it may take some time to do it. Here, it just fell off a cliff. And not only did it just fall off a cliff, but when it did, it's getting a job search. This isn't getting anywhere because depending on the industry, there just aren't a whole lot of jobs out there. And available, but all you have to do is read the newspaper, watch the media in terms of the difficulty in getting a hold of the unemployment agency and getting some of that payments. And it's created some potential huge issues here. And then again, this all plays into the question of access to the courts and the problems that we have with that.
Hey, Greg, can I jump in here for a second?
Yeah.
We have a couple of comments and a question from some viewers. The theme of the comments is back to the COVID considerations. We've some folks here would like to get your take on how the courts and how you as a family law attorney deal with very conflicting views from the parents as to whether COVID is a real threat to children or not. Maybe one parent believes that COVID, as some do, is less of a threat to small children than the seasonal flu. Others believe it's a real threat and are concerned about their kids being out anywhere. You cited the birthday party. And then also a comment about if a parent works in what might be considered a hotspot, like a meatpacking plant or something like that, where the threat of COVID might be quite real and dangerous. How would a judge handle a placement situation when, I remember practicing family law many years ago, and sometimes child placement was difficult enough without considerations of the type we're going through now with the pandemic. I struggle to think how a judge will balance all of that when you have parents who see COVID as a completely different type of risk. What's your take on that sort of stuff?
The additional problem, and I hate to throw problems on top of problems, but the additional problem to that is there is not 100% consensus on either the severity. I know people who overblown. I'm not going to go into the conspiracy theorists, but in terms of mainstream theorists, that the epidemic itself is way overstated, that it's nothing more than perhaps the equivalent of a flu epidemic, and that the evidence is that except for rare instances are less likely to get it, and if they do, they're less severe. There are these anecdotal reports of children getting very severe cases, even of children dying, but we have a median give us horrible story about children getting a child getting very sick or maybe dying. And there are 350 million people in this country. There are horrible things that happen, and that doesn't mean the other 349 have to change in regard to it. The problem is that 100% consensus. There is a general consensus that this is real, that this is more severe than anything else that we have dealt with within our lifetimes. I'm going to take make an analogy here on the risk of getting a lot of angry emails on this. Tom, the logo to you, so I don't care. But the analogy is to the anti-vaxxers. And there is this group of people out there who feel that vaccines are either part of a conspiracy or that they're harmful. Vaccinated. That's a fringe group. And it's based upon a study that came out in England that's been totally discredited, that was withdrawn by the magazine that published it. I believe it was Lancet, the leading British magazine, which withdrew it and said this isn't accurate. And the person who did it even, I believe, losing his medical license and admitting that the data was forged, but some people still believe that. This isn't what we have now. So we deal with the anti-vaxxers. It's fairly easy for the court to say that there is maybe a 99% consensus. I don't know if anything 100% is, and easier for it to make orders. That isn't this case here. There isn't that type of 100% consensus. I think there is a general consensus that this is severe, a general consensus that this has to be paid attention to. But what I think courts are doing, and what I've heard courts are doing, and I believe they're doing in this, is when it isn't 100% consensus, is give parents a lecture in terms of behaving on the conservative side without going to the extent of making the decisions based upon what I call the bubble scenario, which is you keep children totally locked up, that this is the type of thing where with vaccines, there is a minimal, if any, risk and a definite significant benefit from being protected from these diseases. Everything in life has benefit versus risk. And where the benefits significantly outweigh the risk, it's easy for the court to say, hey, this is easy in this. That isn't this case. There is a benefit, but we can't take, in terms of isolating, don't think we want to take children to the point of no contact whatsoever. However, risk is being that significant. I think courts are weighing that, and I think that that's the way they're coming down. So the result of it is a lecture to parties, do the right thing, but not changing the underlying orders. So allowing parents to do what they want, allowing parents to exercise their discretion, which parents should do. And our legal system is based upon the concept, and this is nowhere in any of the laws. This is only my view of doing this for 34 years. I started when I was 6 years old, Tom, just in case you were wondering. That what courts do is set up parameters and sort of say, if you play these parameters, we're going to leave them alone. And the parameters, like at a football field, is maybe between the 20s. It's fairly wide. Now, if their decisions are out of the lot, courts may step in. But court may not agree with it, and the other parents certainly not, but I may not. But I think as long as the parents' decisions are reasonable, that they're telling the court, and we'll say that we're going to play within these boundaries and make reasonable decisions based upon our knowledge, I don't think courts will step in to change that. So I hope that addressed it. I know it didn't answer it, but hopefully it addressed and helped a little bit about it.
Yeah, I think it does. I think it's such a tough issue.
Okay, thanks, Tom. In terms of the support issues, there are two types of support. There's paid, there's what's called dollar expressed orders and percentage expressed orders. The easiest question for me to handle when this thing raised was from a couple of my former clients who are on percentage expressed orders. And the percentage doesn't matter because 50% of zero is the same as 10% of zero. If you're on a percentage expressed order, the support goes to zero, and the amount of the percentage doesn't matter. The really tough one, in terms of, it's tough both in terms of the payor not having any money, and certainly the payee not receiving. Nothing has to be done within the legal system. The tougher one is on the dollar expressed orders, and the concept being that if you're ordered to pay X dollars per month, you have to pay that amount until that order changes. And of course, there are two ways to change it. One is get the other go to court and get an order changing it. The problem is the law changed a number of years ago in terms of the retroactive effect of support modification orders. Used to be back in the olden days, you'd have those days, it was the guy always paying support. Now it's maybe not as frequently, but certainly not infrequent that it's the ex-wife or the mother paying support. But I'm going to use it's easier, the gender-based scenario rather, just because it's easier. So you have a guy paying support. Back in the olden days, he'd lose his job, it'd take him 2-3 months or whatever to find a new job, go back into court, reset support. Court looks at the amount of support not paid in that interim, whether or not the loss of job was involuntary, that the job search was being done appropriately, and if so, then can forgive arrears. That law changed a long time ago. And what the law is currently is that modification dollar expressed orders be made from the date. And again, the statute's important in this, and I marked it because I want to read it exactly, because I think the wording of it's a little unusual. I'm looking at 767-59-1 payment revisions perspective, and it says the court may not revise the amount of child support maintenance or family support that is accrued prior to the date that notice of the action is given to the respondent, except to correct previous errors in calculation. Prior to the date that notice of the action is given to the respondent. So it's not the date of filing, and it doesn't require service. And I don't know of a single case, and trust me, I read every family law case. I read the ones that are published, the ones that are authored but not published, the ones that aren't. even authored the per curiams. I even read the summary decisions. I want to know what courts are thinking. There's nothing on this whatsoever. In today's world of e-filing, I suspect that if the other parent is a member of the e-file system, that e-filing the motion is sufficient to give notice. But a lot of people aren't on it. A lot of lawyers are on it as opposed to their parties being on it. And if it's post-judgment, which most of these are, then is e-filing the motion, which then gives notice to the lawyer who may or not still be sufficient notice under that statute. What I've done in the cases that I've handled, and I have a number of these that I've handled, a couple of them are still pending, is send an email to the lawyer saying, are you still going to represent that person? If I suspect they're not for any reason, immediately give with a link to or an attachment to the motion that was filed, because that should be sufficient notice. It doesn't say should be notice, and then any modifications can be retroactive to that date. There is a major problem that has come up in at least one of my cases, and I've heard about a few more, which is for people on income assignments, which is almost all child support payers today. Now, again, if it's a percentage order, it just doesn't matter. Or if the payor lost his or her job entirely, doesn't offer, so there's no issue. But the problem is where it's significantly reduced, and it arises in the scenario where some people are not laid off entirely, but have their hours cut back substantially. In that case, if you're dealing with a Dollar Express income assignment, that assignment continues. So say somebody was making, just to make this up, $2,000 a month, and they were paying $340 a month in child support, which is and that is, as opposed to laying them off entirely, cuts the hours in half, and he immediately brings a motion to modify support based upon a substantial change in circumstances. Until the court makes an order, there's still going to be $340 a month sucked out of that person's paycheck. Income assignments cannot be for more than 50% of the net disposal. It can create some significant. $340 is, half of the net available, and then we're back into the problem that I've mentioned 2 or 3 times in this, of getting a hearing in court on it at all. Hopefully, and I emphasize that, payees are going to be reasonable and rational in terms, and I would encourage lawyers to encourage their clients. Several where the payees have called me, their former clients, and have said, I just want to check with you about what I should do. And when you go into court on a modification hearing, of course, the first 2 things the court wants to hear is, was the at all voluntary and at all the fault whatsoever of the payor? Did they quit their job? Did they have malfeasance or whatever? And of course, in the past, that's always been an interesting issue. If the person resigned or if they were fired because they didn't show up for work or whatever it was. In the COVID era, that's rarely an issue now. I don't think anybody's going to COVID or causing their income to go down. This is against most people's wishes, intent, and nothing that they could do about it. So they're going to get relief. And I think it looks really, really poor for a payee to challenge it in most of these cases. And I think the courts are going to be putting significant pressure on people to do the right thing, to make concessions regarding not only the future support, but also the arrears that may have accrued. Again, the point of view, we have to tell clients that they need to at least bring that motion. What I did in several cases is e-filed a motion. This is one of the good things about the modern world. We don't have all the stuff we used to go through before. There's even a new provision in the law that just came in that allows affidavits to be signed remotely. It used the affidavits say sworn and subscribed before me. There's a new law that allows notaries, if they're registered, and you have to pay a fee for it, and there's certain hoops you have to jump through, but you're allowed under the new law now to do affidavits remotely. What I did to my clients is, former clients, I just signed the affidavit on their behalf based upon information and belief, and then you can e-file it, and then it's instant send a notice to the other side, and at least you've preserved retroactivity. But they have to do that. And if you have a case like I did where I got a call on Wednesday, my next payment is due on Friday, I said, forget the retainer fee, forget even a fee agreement. We'll work out fees later. Let's take care of the immediate crisis in this and get that filed, and then hope that at some point the situation remedies itself back, and that we can work this out. And again, it's encouraging the payees to be reasonable, because if they're not, I think they're going to look really bad in court. But there are some bad scenarios out there for payees that may not be reasonable, in which courts may be restricted by statute in terms of what happened to arrears. I hope that doesn't happen. I want to discuss a bit some of the procedural issues. I've alluded to them a little bit earlier, but some of these procedural issues affecting this crisis, and just a bit how these may be affecting our practice. I quoted in the outline a few news medias, because you reports in terms of filing rates in terms of divorce, and just for giggles, a obviously doctored picture, which I threw in for laughs, of the crisis over and a huge line to file for divorce. And I just cited 3 source media saying that there's going to be a huge, when people are forced to live together, it's the old saying, absence make the heart grow fonder, and it's really good for marriages when people aren't working together in the home and locked up together over a period of time. I suspect, and I don't have any actual evidence for this, but I suspect it's one of those things that looks good in media reports, and that's why the media reports it. My experience is that filing for divorce is more highly influenced by economic issues, and that most people find that when jobs are not either available or paying the same rates they were before, that their savings of 401ks have taken substantially, mostly or entirely come back from where it was, that most people prefer to wait than file and initiate a divorce where they feel that their economic circumstances are not ideal for it. The is where there is abuse situations going on, physical or verbal abuse. Again, I'm guessing we're going to see a whole bunch of studies come out afterwards, and all this. I don't think you'll ever see a study saying that COVID situation and people staying home and was good for their marriage. Maybe we will, but I'm guessing there's either a lot of confirmation bias, or maybe it just isn't true, and that's the reason. But I suspect the studies make better newspaper play when they talk about the issues, the problems, and people fighting and arguing. So I've given you those newspaper studies. I should tell you as well that the American Academy of Matrimonial Lawyers published yesterday a survey of its members, said that they believe that filings for divorce have increased during the COVID crisis. So there are a number of divorce lawyers around the country who apparently believe that's true. I have not really studied it to a scientific degree. I've looked at it from going on in various counties I practice on, and it looks to me that filings are significantly down from what I can see. Whether this over time is tell. The more significant issues of the procedures that we're going through as family lawyers. And a couple times before, access to the courts is obviously the biggest one. The Milwaukee County Clerk's Office issued a statement about that their estimate is that when the crisis is resolved, that beginning at that point, the backlog for civil cases will take 2 to 3 years to remedy itself. I'm a little suspicious of that, partially because I don't know how they measure that, because Milwaukee County's always been backlogged. So I don't know if they're talking about total backlog or the additional backlog, or how that plays out in their opinion, but at least that's the opinion of the Milwaukee Clerk Office. I wouldn't even delve in terms of what's happening with the criminal courts, except for the fact that it would seem to me that the difficulty in doing jury trials when you have people in custody and with speedy trial demands means that the courts may be moving some of their resources from what is been used for family courts into criminal courts, be important and have a higher crisis level than many family courts are. As a result, getting into courts and getting trial dates always difficult in Milwaukee County. I think it's going to get more difficult every place else already is. I had a status conference case where we just are moving the case along. Me, somebody who's totally lost all income. People own jobs that just aren't making any money. And they say, how long do you think this will take before we know what the future is going to be? And my answer is, you got me, Judge. So he said, we'll give another status date. And earlier this week, the earliest status date available for status conference was December. It was 4 months just to get back on the court calendar for a status. I shudder to think how long it would be even for a trial date. I do know of some cases where courts have been holding contested hearings. Milwaukee's going to isolate 2 courtrooms to use it. Some courts are doing Zoom trials. I've talked to various lawyers who have done them. I've done several hearings on Zoom. Titled Your Own Opinion. I think in certain simple and easy cases, it's perfectly appropriate. It's sort of odd in terms of being able to try a case virtually. Communication experts say that communication is 80% nonverbal, and which is why I always like to meet with clients in person, and I much prefer to do a hearing in person. I did find one small advantage from my point of view on it. I had a hearing earlier this week where again, on a support case where the question is how COVID affected everything. Everybody was wearing masks. The ex-husband was pro se, and how do I put this kindly, made some relatively silly arguments. It was in front of a judge I know quite well and does not like lawyers making faces. And nice things I could kind of do behind the mask, and the judge couldn't see it. I suspect in other circumstances I might have been reprimanded for smirking during the hearing. So the mask can hide that. On the other hand, I find it difficult to talk to my client when we're both wearing masks. It was a court table. Boy, this is odd, where there's a partition between me and the client. My client wants to write notes, wants to whisper in my ears. Some way that's a good thing. At least the client can't whisper and interrupt me. It's just an odd circumstance in terms of being able to litigate cases under these circumstances. But we sort of do the best that we can under the circumstances. I have a hard time not trying to look for something positive in very, very bad circumstances. And there is so much negative, want it to go away. So I have an article, my outline, it says anticipate a publication. It's actually available online and will be in the Wisconsin Law Journal, one in a dark cloud. A quote that my mother used to say, my late mother used to say, that it takes a very very ill wind not to blow. So I felt that let's look and see if there's anything in the least bit that we come up with in this that has any positive to it whatsoever. So I could think of two that are purely personal with family law per se, but I'll look for anything positive. One is that my morning commute is now a pleasure. For those of you outside of Milwaukee, Madison area, may not make any difference to you, but I live in a northern suburb. It's get up extra early, and I'm usually in the office before 7 a.m. just to avoid the traffic, and I usually stay till around 6. Not because some days I'm busy, I have work to do, but even if not, I just don't like sitting parked in traffic, which could happen. Hey, no problem, no issue. And I can come in whenever I want in the morning, leave wherever in the afternoon. There's a little bit of traffic now, but that's one good thing. And then the last one on the list in my outline is my dog loves. I have a very friendly, energetic black lab. She's having a really good time. She gets more walks than she ever has. I've met a whole bunch of neighbors that we get to talk to and share things. And those on the non-legal side are some of the positive in this. One of the positives in this is courts are doing pretrials by Zoom and sometimes by telephone. And just to have a little bit of fun with this, the first trial I did was probably in March. And I get this notice right after the shutdown that I suddenly realized I don't have a camera on my computer. So I asked Kathy, my office manager, if I need a new computer, whatever. She says, no, we just get a plug in. And she ordered it. I said, you better hurry, this hearing's coming up. And it comes in that morning and it worked great. You plugged it in and in the port, you put the camera on the computer and there I am. And Kathy walks in and I said, let's see how it looks. I logged into the court thing. You get a notice, court, please stand by. Court will add you online as soon as everybody's available. So there's a glare from the window. We're on the 19th floor here in the Chase building in downtown Milwaukee. And Kathy said, let me lower the shade. She walks over there behind me and says, but Kathy, who's barely 5 feet tall, climbs up on the windowsill to unknot it. And as soon as she does that, it goes live. And the first thing the court says is, Mr. Herman, has somebody tried to jump out of your window there? And I yelled, Kathy, don't jump. It's fine. I will pay you this week. I promise you. At least it started the hearing off with everybody laughing because it looked for the life of us that she was about to jump out the window of the 19th floor. I readjusted the camera as I did here so that you don't have to worry about anybody jumping out the window here. But it's an odd experience to do that. But it's a positive in this sense. I've never quite understood the idea of two parties having to pay their lawyers to drive or even walk, and sometimes walk up to the court, go through security, which can take some time depending where you are, wait for the judge, meet with the judge, say we don't have a resolution, we need to come back, and then reverse the whole process, go back to your car, return to your office, and two parties having lose an hour, so maybe a whole day of work for meeting with the judge and saying, we have a resolution, give us a date to come back. Many counties I know understand that and have long done it by telephone, where you pick up the phone and instead of all of that inefficiency to the court, either by telephone or by Zoom. Now everybody's doing it that way. And I'm hoping is that that will become a permanent fixture. Defaults are required by statute to be in person, but a lot of courts are now allowing the parties to file affidavits or do them by Zoom for a requirement. We let parties waive not only statutory requirements, but constitutional rights all the time. Criminal defendants give up rights to jury trial, rights to prison sentences. And if that's allowed, I certainly think divorce parties would be allowed to waive the statutory requirement of personal appearances. I attached one of my columns to Wisconsin Law Journal, and I discussed this. A formal group of divorce lawyers I mentioned to earlier, require parties to appear in court. Because one of the concepts of American jurisprudence is we have 50 states plus the District of Columbia, and we have 51 different sets of ways of doing things. And maybe we should learn from our neighbors in terms of what they do and is it good or not working? Well, the answer is most other states do not require personal appearances for divorce. Some do it by telephone, a lot just do it by affidavit, and you mail in a settlement, you get the divorce decree back. Well, the argument of people is the judges want to see the people, make sure they know what they're doing, make sure they understand what they're doing. And if there is a claim later that they didn't understand what they're doing, you have the transcript. Well, that's certainly helpful. But then I go to the lawyers from other states and I say, how many times in your states has there been an issue or a problem of somebody claiming later they didn't know what they were doing, they didn't understand it, in which you wish there was a transcript, and nobody could think of a single instance where any of those problems arise? Say there are, I don't know, several thousand divorces a year in Wisconsin, and say once, twice, there's an issue years later, this would have been helpful. Should we really be taking off of work and paying their lawyers to something that could be handled far more efficiently? I'm hoping that this is something that we can learn from, and that a positive in this is in the future, the defaults can be done either virtually, or for that matter, you don't need the appearance at all. You just mail in the settlement agreement. And how many times does a court reject a settlement agreement? In my experience, almost none. And for the one time it happens out of a blue moon, you can deal with that on an individual basis, but it would save clients substantial amount of money, not only in terms of their personal lives. And then it isn't a family law issue, but since I'm on a rant, I might as well stay on the rant. I've never understood why Wisconsin and U.S. Supreme Court are not televised. We allow trial courts to be hearings to be televised in most instances. Although there's a story in the paper today that a Milwaukee court is not allowing YouTube television of its court hearings based somewhat on Marcy's law to protect victims, and partially because of fear of witness intimidation. Okay, that's your case, maybe a perfectly appropriate ruling, but these are supposed to be public hearings, and in most cases, with technology today, it's fairly easy to do that, and we allow it in most cases, subject to judge's discretion. In my experience, I've been honored to appear before the Wisconsin court, either on rules or on cases. I think it's 6 times now. There has been nothing that I've done in the practice of law that has been more thrilling than to appear before the Wisconsin Supreme Court, with one exception I won't mention, where it was a miserable experience, but thanks to one justice who's no longer on the bench. So 5 out of the 6 times, it's been just a thrilling experience. These are, for the most part, really bright judges who have really good law clerks to assist them, and usually really bright lawyers discussing how our legal system affects the world and society and should be molded. We want people to see this. We want this to be out there. It's something we should want to have happen in terms of the legal system. So Wisconsin Supreme Court does have audio. Go on TV. Judges look awfully good in those black robes. In terms of U.S. Supreme Court, they're now starting to do some of this televised, and I hope that they continue to do so. So that's my rant on that, and I'm hoping that some of these silver linings, they certainly don't overcome the negative going on in terms of this. They are certain things that might help make some small improvement, and given what we're all going going through, the anxiety, the fear, the monetary problems, anything that's a positive is welcome in this.
Hey, Greg.
Just at the end, and discuss.
A viewer would like to know if you are doing initial meetings, initial consultations with clients in person. I know from my perspective, and when we talk risk management, those meetings are so critical, not only for the client, but for the attorney. Is this a fit? Is this a case I should take? Do you need a different lawyer? Are you doing those in person? Some lawyers, I think, are struggling with that.
Yeah, and I struggled about this as well, because as I said, I have my wife has certain medical issues, and we have these grandchildren that we love to see, and we don't want to either infect them or get the disease and not be able to see them. So I've discussed this with various people in terms of what we ought to do. We reached the following conclusion, and it's based primarily on what I said earlier, that communication experts say communication is 80% nonverbal. And what Tom alluded to, I think the most important part of my representation is the initial consultation with clients, where clients see me, decide, is this the type of lawyer I want? And I see them, and I'm fortunate enough to be in the position of not having to represent people on occasion. What I've done is I've told the client as follows. I've said, we are now seeing people in person. There was a period of time we were not. We have the following rules in effect. A, masks are mandatory in the building. They are voluntary in my office. I do not wear one in the office. I wear one when I walk to the building, sometimes even to the bathroom, but in the office, our masks are not mandatory. I'm not going to be shaking hands or hugging. We have hand sanitizer all over the place. In the conference room that I'm seated in now, and it's a fairly large conference room. I don't know if we're 6 feet apart. We actually did measure it. Sitting ridiculous ends from each other, but relatively close. I think we were at 5.5 feet. And I think that it's perfectly serious. Like everything else in life, you have to weigh the risk versus the benefit. I think if people wear masks coming into my office, if we sit distance from each other, and if we don't visit each other, and use hand sanitizer, if any documents have to go back and forth, I think we'll extend that the benefits overcome that. Every client I have asked so far, or potential client, and in my mediations, and I've asked the parties, would you both be willing to come in? We'll sit at triangles in terms of the room. Everybody has said, yes, we want to come in person. And so we enact the distancing, we do the hand sanitizer, and so far it's worked out. So I promised to leave, and I only have a couple of minutes in terms of predict where I think we're going. And a couple of minutes is all I'm going to need for it, because I don't have the faintest clue. I have a friend of mine, I was talking about this, and she said, why don't you just as a prop bring out a crystal ball and just say, hey, everybody look into this crystal ball, and your guess is, I prefer to instead quote the person I believe is the greatest philosopher. I refer, of course, to that great philosopher, Yogi Berra, who said, or may not, Yogi's famous line says, I did say all the things that I said. One of my favorite Yogi quotes that he may or may not have said is, predictions are very difficult to make, especially about the future. And as typical with yogiisms, it sort of makes no sense, while at the same time it does make sense, because at the bottom line in this thing, nobody predicted this was going to happen. Yeah, I know there were some people who said, yeah, we're going to have a virus that happened, but nobody predicted this virus, or certainly the severity or the extent to which everybody fell off a cliff. So if you didn't predict this was going to happen, you sure aren't going to be able to predict what happened in the future. And so I'm with Yogi in this. This prediction is too difficult to make. You want me to tell you what happened in the past, where we are now, that's fine. In terms of the future, I don't know. I want for listening and paying attention. Please stay safe. Stay healthy. Get by this and back to the time where I can rant about other things. Tom, thank you for asking. If anybody does have any questions, like to contact me directly, my email is on the material, gherman@lobherman.com. Please send me an email, or my phone number is on there at all as well. And always be pleased to talk to people. Tom, thank you so much.
Thank you, Greg. Very much appreciated. A lot to digest and chew on for all of us, certainly during this unusual time. Greg, thank you again. All right, we will take a 15-minute break. It's now 10:15 on the button. Greg nailed it. So we will be back at 10:30, and we will have Bill Williams take up estate planning issues. So we will see you in 15 minutes. And Greg, thanks again. See you all soon.
Live.
All right, welcome back, everybody. It is 10:30 on the nose. We have the second half of our program now coming up. We talked a lot of family law stuff in the first half. We are going to now tackle estate planning with Bill Williams. And just a couple of reminders. This entire 3-hour program today has been approved for 3 CLE ethics credits. And also, you will get an evaluation form by email after this program today, and we would appreciate you taking a minute or two to fill that out for us and send it back. We use your feedback to help plan for future programs. So if you could do that, thank you very much. All right, second half of the program, Attorney Bill Williams is here with us. He's a shareholder with the law firm of Bell, Moore and Richter in Madison. Bill received his law degree cum laude from UW Law School in 1985. Bill's practice focuses on probate and estate planning for individuals, including business owners, representing businesses of all kinds, including regulated public utilities, telecommunications providers, and healthcare professionals. Bill is a member of the State Bar and its business law, real property, probate, and trust law, and energy and telecommunications sections. And so we would like to introduce to you Attorney Bill Williams to take us away. Good morning, Bill.
Good morning, and thank you, Tom. I appreciate the introduction, and I thank everybody for participating this morning. I want to start by explaining the origin of the subjects that we'll talk about today. My practice is I am an estate planning and probate attorney, and I also represent defendants in legal malpractice cases, primarily in the estate planning area. So what I looked at is a completely unscientific gathering of what we're seeing both in our firm's estate planning practices and in our legal malpractice defense. I started this with the idea that we'd be talking about what the pandemic has done to this practice area. And as I was working through this, I've sort of come to the tentative conclusion that while there are some things that we'll talk about that are new and caused by the coronavirus, what may be more prevalent is an acceleration of certain trends that we were already seeing in the estate planning area as a result of the effects of both the illness itself and its effect on social distancing and the ability to just normally conduct relationships with people, and its economic impact. So first item is what I would call an increase in cases where we've been contacted either by trustees or beneficiaries about getting the money out of a trust and to the beneficiary sooner than is provided in the trust terms. This was something that was starting to happen as soon as the state tax exempt amount increased and people found, for example, they no longer needed the irrevocable life insurance trusts that they were using because they just made the determination that there was no way they were ever going to need that coverage form of insurance to pay estate tax. So, but we are seeing it more now as a result of we run into people who want to help out their children or grandchildren who are having tough times because they're losing jobs or because of other effects of COVID-19. We also hear from trustees, more often in my case, it's individual trustees as opposed to institutional trustees that want to be proactive and want to help. And it's very important in this, as in everything we're going to talk about today, be very clear about who your client is. You want to be sure that everyone that's involved in a transaction that involves a trust understands that you either represent the trustee or the beneficiaries, or I hope not all of them. the trustee does not satisfy their fiduciary duty, and this is no surprise to those of us on this call, but it is to some individuals who have been thrust into the role of being a trustee, that giving the beneficiary what he or she wants is not satisfaction of your of your fiduciary duty. First of all, the trust has to authorize anything that the beneficiaries or sometimes even the settlor wants to do with the trust. Failing to follow the trust terms is a breach of fiduciary duty, no question about it. A situation where people want distribution accelerated or something like that, and there is no authority to do it under the terms of the trust, you're looking at either trust modification or a termination of the trust. Another thing that we see sometimes is what I call the nagging spendthrift beneficiary. And you'll get a call from a trustee or even the creator of a trust saying, so-and-so is constantly after me for money. Can't we just give it to him and be done with this? And the answer is, it depends. If terminating the trust is something that is appropriate to do, and the trustee still has a fiduciary obligation, if they're involved in the trust termination decision, to make a prudent determination as to whether that's a good idea. It is not just hypothetical that a beneficiary can say, give me all my money, and trustee will do so, and then they'll spend it, and then a lawyer representing that beneficiary will say, well, you shouldn't have done that because you knew or should have known that this person couldn't handle the money, and the whole purpose of the trust was to protect that individual from themselves. So that's something that sometimes you have to educate the trustee or the settlor of a trust about. To protect those people and yourselves, the trust agreement doesn't authorize what people want to do. You're looking at a modification or termination of the trust. Wisconsin's adoption of Uniform Trust Code provisions has been very, very helpful in clarifying how we go about amending or terminating trusts, even irrevocable trusts. Previously, there were things that people did, and we were always wondering whether anything short of a full-on tested court proceeding would be legally sufficient. That is still sometimes an issue if the IRS is involved, but there is, I think, a lot more comfort with using non-judicial proceedings to modify or terminate trusts. I'll point out that it's the type of the trust, who's trying to amend or terminate the trust, and who's on board determines which alternatives you can pursue. And I'll point out, first typographical error in my text is that the citations I was looking for under item B1 on the bottom of the first page, it's section 701.0410 and 701.0411 through 0416. And there are even more provisions in chapter 701 that talk about terminating or amending trusts. Here again, it is absolutely essential that it's clear not only to your client, but to everybody involved in a transaction modifying or terminating a trust, who you represent. There will be conflicting interests in a situation like this, and it's very important that everybody understand that you are not advising someone that you did not intend to advise. Putting that in writing at the front end is always recommended. Another thing to clarify early and in writing is your client's position. A trustee or settlor or even beneficiaries can take two positions concerning these trust terminations or modifications. They can either not object or affirmatively approve. And you can easily see situations where a trustee may want to take the position that they're not going to oppose, but they're not affirmatively endorsing a particular course of action. In these situations, it's critical that at least your client understand that trust terminations and modifications have potential income, estate, and gift tax consequences. A lot of times, accelerating remainder interest can constitute a gift on behalf of the current beneficiary. Another very important point, make sure that families understand, is the difference in tax basis that results from a distribution that's made as a lifetime gift as opposed to a testamentary bequest. Parties that are foregoing interest in the trust have to be clear that what they're doing is irrevocable. There's no give back, and that it's not acceptable to say, well, I'll give it to my kids, but I'm sure they'll give it back to me if I need it. We're all aware of situations where that just doesn't work. Generally, a trustee is obligated to treat all beneficiaries impartially, subject to the terms of the trust, of course, and that's something that has to be kept in mind anytime someone is talking about changing the terms of the trust or terminating it. We now have a clearer authority to decant, which is transferring of trust assets into a different trust vessel. That process raises similar issues for the fiduciaries and the advisors of all the people that are involved. Another issue to watch out for in this area is abuse situations. If you get a call from a beneficiary that says, hey, mom wants to terminate the trust now and give me all the money, even though that's all she's got to live on, you better be careful. The rules that we all live by concerning undue influence, coercion, and capacity apply equally with these trust modifications and terminations. Here again, critical to be clear who you're representing. Last item on this topic that I wanted to mention is, we've seen some action, I'd call it, on this question. Trustees with discretionary powers sometimes have the benefit of a well-drafted trust provision that addresses the question of whether they are to exercise their discretion regardless of other assets available to a trust beneficiary, or they're supposed to consider those assets before making a discretionary distribution. Sometimes that language isn't in there. And I had hoped to come to you with Solomonic wisdom on what you do then. And I don't have it. Looking at this, the outcomes are so case specific, and I would submit outcome determinative, that I don't see a lot of help in the case law here. If you don't have clear language in the trust about whether other assets available to the beneficiary to be considered, the best thing you can do is pore over the entire trust, context of the trust, and try to make your best decision. Even in the best situations where a clause exists, there's another fork in the road. If the clause simply says, and the trustee is to consider the other assets available to the beneficiary, what's the trustee's obligation? Is it just limited to assets of which the trustee is aware, or is the trustee obligated to investigate the availability of other assets? Here again, drafting can solve a world of problems. And if your trust instrument says that the trustee is to consider assets that are known to the trustee, they're in a much better place than if they're in the dark about whether they have to fish around and try to figure out what the trustee's got, what the beneficiary has access to. Next topic, and there will be no smooth segues in this presentation. This is a COVID-specific item. I think we've all seen at least some people expressing interest in getting estate plans done, both people that have never done them before and those whose files have been sitting dormant in your office for a while, who suddenly decide, now's a good time to do this. I'll talk separately about the mechanics of preparing and executing estate planning documents in the physical distancing world. But there is sort of a threshold consideration that attorneys need to undertake. And I'm seeing this in people's practices. If you've got an increase in your estate planning work, you have to decide whether your office can still do it, given partial office closings, just the simple logistics of getting a conference room ready for a will signing and then taking it down. It's not that different than physician or dental practices, where you can't do as many will signings in a day, just like they can't do as many procedures in a day because it takes longer to prepare the room and the people involved. Plus, there's just the question of whether your staff and you have to be careful about your viral load. If you've got a practice with a high volume, it's fair to consider whether you should be doing as many will signings as you were doing before. I point out that the Supreme Court rules specifically say that a lawyer's workload has to be controlled so that each matter can be handled competently. That's set out in one of the comments to Supreme Court Rule 20:1.3. One other thing that I have seen is, as the concern about pandemic ebbs and flows, so goes people's zeal to complete these projects. I've had people who are, how soon can we get this done? And then when I'm following up with them, they're not quite so keen anymore. And it's because maybe they think they're not going to die or something, but for whatever reason, some people will not follow through. And then what do you do? It is not as simple as saying that it's a lawyer's duty to get a will done as soon as possible. That is not the state of the law. What is required of an attorney is to get client to complete their estate plan as soon as the client is ready and able to do it. And that's not the same thing. In a contested estate planning situation, evidence that someone felt that they were rushed or pressured by their family to get an estate plan done could affect the enforceability of the plan you've put together. So you need to kind of thread the needle on what people want and how much prodding you need to do. Now, that said, the case law is interesting on claims that an attorney was negligent because they didn't get somebody's estate plan done before that person either died or lost capacity. The relatively easy and unfortunate cases from a defense standpoint are those where an attorney misses an appointment and the would-be testator dies 2 days later, and this happens, or witnesses aren't available and it's the lawyer's fault. Then there's always the question of if you're doing a remote will signing where you're not in control of the situation and you're relying on others to get witnesses there, things like that. What's your responsibility if that doesn't happen? We all, I think, rely heavily on our ability to control the document execution environment in our offices. Sometimes we don't have that luxury anymore. More generally, what's your responsibility if your client goes dark on you? The legal standard that you'll be held to for malpractice purposes is whether you've frustrated a client's clear intent to go forward with a particular estate plan. If you're not hearing from your client and you can show that you made reasonable efforts to contact them and they either didn't respond or said, I'm not interested in doing this anymore, you're going to be okay. If someone, however, passes or becomes incapacitated and you don't have any evidence that you responded to their revisions or their request to make an appointment, you may have risk. As I mentioned, client's constitutional right to make a will includes the right not to make a will, and client must not be coerced into signing documents that they're not ready to sign. So this is a situation where documentation helps you. Documentation will always help you more than it will hurt you. And this day and age, it's pretty easy. Emails are good. Emails are even better if you get a response or at least a receipt that you know that they were sent. Phone calls are good. You should keep a log of the phone calls you make. But at some point, you have to be able to stop. When someone's just not responding or can't make up their mind about something, you have a decision to make. And that is, do you leave the file open or do you terminate the representation and send a final bill if there's anything to send? I think that at some point, you are better off terminating the representation with formal disengagement letter saying, we worked on the plan, this is how far along we are, or, you never got back to me, and I am therefore terminating our representation of you in this matter. If you would like to pick this back up sometime, please contact me, but you won't be hearing from me again. That's a much better place to be than just leaving it hang. And I know there is a reluctance to terminate engagements, but there are circumstances where you are well served in doing so. So turning on to the next topic, talking about powers of attorney. One of the questions that Tom asked me when we were talking about this program was whether I thought the pandemic was going to make it more likely that durable powers of attorney would be activated. And with that, the powers of attorney for healthcare, particularly among healthcare workers. I have seen very little of this. I do think it's very important, though, to bear in mind that powers of attorney are something that a lot of attorneys sort of include as, for lack of a better term, a kind of a throwaway in their estate plan. They're drafted without very much thought. Who do you want to be your attorney if you're incapacitated? Who do you want to make your healthcare decisions for you? Fill in the blank, you hand it to them, and you're done. These arrangements, especially one aspect of COVID-19, is that people can be incapacitated for months, and sometimes they recover and sometimes they don't. But during that time, they need to have powers of attorney that are useful for them. It is very important, again, to bear in mind who you're drafting this for. Call from someone who says, so-and-so wants me to be their attorney, in fact, is a call that you should be cautious about. Who are you representing in that situation? Is the person who's giving this potentially very important power making this decision of their own free will, or is there coercion or capacity issues? One particular area that we are seeing litigation on concerning durable powers of attorney is the agent's gifting power. Independent of claims that the attorney, in fact, is just looting or taking all the assets for themselves, abuse of gift powers is an area that we do see questions raised on. A fiduciary's power to make gifts has to be explicit. The fiduciary's power to make gifts to the fiduciary or persons related to the fiduciary should be crystal clear. It's also worth noting that giving the power to gift to an attorney, in fact, to themselves or their families, can have potential estate tax consequences if you've got clients who are concerned about estate planning situations. This is an instance where your boilerplate language needs to be looked at. The attorney can make gifts where it provides estate tax benefits language. If you still have that old relic in your documents, really doesn't cut it anymore, because most of our clients, or most of my clients at least, don't have estate planning issues, and a gift would never provide estate planning. There's a continuum here. I like to start from the premise that somebody's attorney, in fact, will have no authority to make gifts. It avoids trouble, and it focuses the attorney, in fact, on what should be their single unitary purpose, which is acting in the best interest of the person who's granting the power of attorney. That said, for most married couples, it is very useful for the agent to have broad authority to make gifts to the person's spouse. While that can have some estate tax implications, it's because of the marital deduction, it's still a very good thing to be able to move assets between spouses in a situation where there's not a concern about abuse. Beyond that, the agent's authority to make gifts is something that should be looked at very carefully, because it's, again, a basis for elder law claims, and disgruntled family members can be concerned as well. Sometimes agents will have the authority to make gifts to whomever based on our usual language, the established pattern of giving demonstrated by me before I became incapacitated. Be careful with that language and know what the implications are. I think you just need to be cautious if you're going to use that language at all. Another aspect of powers of attorney that needs to be looked at, especially considering the possibility that the agent could be serving for a long time, is the sort of routine provision that the agent will serve without compensation. At a minimum, they should be entitled to reimbursement for their expenses. That only makes sense. But is it reasonable to sign somebody up for years of what could be a very substantial obligation without any compensation? That's something that could go to the willingness of people to serve as your client's agent. And this needs to be thought through. It's easy to say, well, the agent should get something for their service. The harder question is how much. I'm sure many of you have ideas about this. I've heard a range of creative and not so creative solutions for this. It's something that you need to work through with your client. And if it's a situation where someone is being asked to serve, it may be appropriate to talk with them about what they feel they would need in the way of compensation to serve, because power of attorney won't do any good for your client if the agent refuses to act. We routinely select person's spouse as their agent under a power of attorney. That's usually entirely appropriate, but it shouldn't be automatic. In blended family situations, there can be instances where the surviving spouse, or I'm sorry, the person's spouse is not the best choice, even if they're otherwise suitable. Last thing on durable powers of attorney is, if there's something that doesn't get much attention on these, it may be alternate attorney in fact designations. Sometimes it's hard enough to extract a name for someone that your client wants to have serve as their attorney. In fact, getting them to name an alternate can be painful, but it's necessary. It's particularly necessary if they have named their spouse as their primary agent. And that's because spouses are together a lot and they get in car accidents together. They have other mishaps together. And now they can, they're together enough that they may infect each other with COVID-19. So it's more important than ever, I would say, to have a thoughtful selection for an alternate attorney in fact. That would apply likewise with powers of attorney for healthcare. And on those, we all like our own forms, but we need to have a form that works. The worst failure for a power of attorney for healthcare, if you don't have it, is having one that the hospital or clinic will not honor because they can't understand it, or it looks different, or for whatever reasons they can come up with, some legitimate, some not. They say, well, we just can't use this. And in that situation, what's your remedy? Are you going to go to court and get a court order? Your client may already have passed on, but you need to develop a form that doesn't look threatening. I submit that the best thing to use is the state-generated form because it's the one that healthcare providers and hospital administrators will be the most familiar with. Other considerations, I'm sure many of you have run into the situation where somebody wants both of their kids or all of their kids to collaboratively make decisions about their health care. That simply doesn't work. You need to do whatever you can to dissuade people from picking co-healthcare agents serving simultaneously. You can assure them and have them work with the family so that you're going to pick one person and that person will talk with the other family members, but you need to have a single agent, one at a time. I represent physicians and they tell me that it is an absolute nightmare when they have to deal with more than one person who's got authority to make a life or death decision. It tends to lead to deadlock and it tends to lead to simply to disagreement. I'm going to shut my window 1 second. Sorry, I have a neighbor who can't seem to mow his lawn often enough. But anyway, as I was saying, it is also easy for us to pick someone's spouse or child as a suggested nominee for a power of attorney for healthcare. You're not doing your job if you leave it at that. It's two critical elements for a good healthcare agent are that the person has to know what the individual's wishes are and that they'll carry them out. I have sat in conference rooms where I've had one spouse saying, anything goes wrong with me, I want the plug pulled. And I've looked over at the spouse whose eyes are as big as dishes, knowing that she would never be able to give that directive. And that person simply shouldn't be forced to serve. And it can be even more acute with children. Parents will routinely say, well, if my spouse can't do it, then it'll be one of the kids. And that's often a very good decision. But there are some children who simply can't do what needs to be done in a situation like that. And it's something that needs to be talked through with your client. I want to talk about special provisions in powers of attorney. Even the state form has an opportunity to add different language. I advise people to be very careful about this, and I even ask to see what they're proposing to write, because anything that contradicts or creates inconsistencies concerning the directions can lead to failure. What happens is, if the language is contradictory, the hospital administration locks up, says, look, we can't work with you on this. We'll need to convene the bioethics committee or something like that. So be very careful writing people's additional wishes into these documents. I personally have gone so far that in most cases, I don't use both a power of attorney for healthcare and a separate advanced directive declaration to physicians. I know other attorneys I respect greatly do that. I'm always a little concerned about how those documents sync up. And I think it's something that needs to be considered when you're putting these estate planning documents together. So last word on this is we spend a lot of time on the revocable trust. We spend a lot of time on the will, and it's, oh, by the way, we've got these powers of attorney, but they're very important and they need to be worked through carefully with the client. My next subject is the truly COVID item in the agenda, and that is, how do you get documents prepared and signed during this pandemic? As I was working on this, I started to wonder whether this section is almost obsolete, because I am seeing that, in our office, we've developed practices where we've gotten people comfortable with coming in. We've got a big conference room with just a few chairs in it. We've got our assistants standing at the side. Everybody's getting their temperature taken now, masks. We've got the whole process. This was a big concern earlier, even to the point that some attorneys cleverly, I thought, were using what is maybe tastelessly, but I thought humorously referred to as a drive-by execution, where the client sits in the car and the attorney overseeing the document signing and the witnesses are outside and contact's minimized that way. I'm not sure how completely effective that is, but I thought it was a very clever workaround. And this is a very difficult situation for us in the practice, because unlike the situation where documents can be notarized remotely, or with the deed, there are alternatives to notarization if you can authenticate a document. I haven't seen any liberalization in the requirements for valid execution of a will. I'm not comfortable with the premise that watching somebody or being in a different room connected by video satisfies the requirements. Everyone has to make their own decision about, is this the best possible thing I can do under the circumstances? But I think we all feel much more comfortable when we've got the testator in the room with us, with the witnesses, the way we've always done it before. The electronic signing regimes, unfortunately, don't seem to be sufficient to satisfy the literal language of the statute, and the legislature hasn't really provided any help with the very important job of modernizing our law in this area. I'm hoping I don't have Greg's crystal ball either, but I'm hoping that that's something that eventually the legislature will turn to, and hopefully with the bar will develop some way of modernizing the document execution practice.
Hey, Bill, we have a question.
Sure.
A viewer asks, for will signings, what is your opinion on dropping the self-proof affidavit page so the attorney can be a witness and minimize having two additional witnesses gathered and present?
I think in difficult situations, that's a responsible, best case. That self-proving affidavit is very helpful, but it doesn't go to the validity of the document, and you're better off making the choice that leads to a validly signed will, even if it leads to a little additional work when you get to the probate, than not having the document at all. So, first preference is to find a way to do it full-blown self-proving. But if the logistics just aren't there, you are better getting a valid will in place. Then I don't think you're going to have a very good defense if will signing doesn't take place and your testator passes away or becomes incapacitated, that, well, we just couldn't get the self-proving part of this done. That you can even do that later. The law, I'm quite confident, is that the self-proving part can be done later. So by all means, if it's get the will validly signed or not, get the will signed. So I think that's a good point. And a basic thing here that I think again, as people get more comfortable with living under this situation, I think clients need to be informed at the outset what your position is on how they need to sign the documents and what they need to sign. If your position is that they've got to come into your office and sign the will in front of you or one of your colleagues, tell them at the outset so that you're not way down the road and they're saying, well, I just don't feel comfortable doing that. If someone is that concerned, then you better find that out at the front end. Likewise, attorneys have to make a decision about what they're willing to do. I was very leery about going to people's houses, even though this was offered, to do a will signing, because I don't like doing that in the best of circumstances, but now I just wasn't sure how safe that was. Each attorney's got to decide if you're an immune compromised individual, should you be doing will signings? I think that's something that you've got a professional responsibility to consider. We all know how much fun it is not, as Greg pointed out, to talk through a mask, but it's kind of where we are. And if you're not willing to do that, then I think you have to make a decision about what you're doing with your estate plan.
Bill, another question is, what is the advantage of a self-proving affidavit?
It moves the informal probate faster. And that is certainly an incremental benefit that in the old days, we never gave a thought to it. Why not? We've got, it's in your office, you got plenty of people around. But right now, it's, I think, a fair question whether you hold up a will signing until you get what I consider, extra people involved to get the will done. It is important to get the will signed. I can't imagine that an attorney is going to be criticized for foregoing the self-proving affidavit at the will signing because they made the decision that it was important to get the will done right now. The converse, I don't think holds. If somebody is saying, well, we can't get all the people, so we're not going to do it because we can't do the self-proving affidavit, I think you could be subject to criticism for that. There are other things to consider here, which is we're in worst case scenario situations. Maybe one of your clients is already sick, and you don't want to knowingly expose yourself or your staff to someone who's ill. Are there alternatives to signing a will? A lot can get done with POD or TOD designations, which have to be notarized, but don't require the full formality of a will. If somebody's sick, I don't know if we want to recommend that they go to the bank to get something notarized, but using documents to change beneficiary designations and pay or transfer on death designations might get you through until the client or you or society reaches a point where you're more comfortable with the signing. I also think this is one of the great things about a revocable trust. And I know our practice is we set those up to be signed just like a will. And they even have their own kind of equivalent of a self-proving affidavit on them. But trust doesn't even literally have to be in writing to be enforceable, although you would have to prove it up. But a signed document, if all you can do is get the person a document that they can sign with nobody around, that may be your best solution. So that's something to keep in mind. So one last wild card consideration, and this could probably be a presentation in itself, but
hey, Bill, before you get to that, can I throw another question? Sure. Actually, a viewer has two of them. One is this: is it common for power of attorney for finances to not take effect before a designation of incapacity?
I can only speak to my practice, but when I put it to people that they can set this up so that it either goes into effect right away or it can go into effect only when they're incapacitated. And there's probably an age or condition variant here, but most people I know don't want to give that power even to their spouse until they're incapacitated. Now, I think that said, it's something that should be discussed, particularly if you've got an elderly client or someone who's got the risk of becoming incapacitated, that if they really trust the fiduciary they've named, it makes sense to put that person sort of in office right now so that there doesn't have to be a determination about it. One variant on that is what I do is even my springing document says that it can be activated at the written direction of the person who's given the power of attorney. So it would apply either if the person who's giving it is incapacitated or the person who's given the power of attorney says in writing, I want to activate this power of attorney. And that can be useful if someone's going overseas, if we ever go overseas again, or in other situations. But that's a nice blend. And I think this is a good question. And I think it's one that we often tend to overlook. Although it's funny how infrequently my married clients are completely comfortable handing over the keys, if you will, even to their spouse.
And then question number two from that viewer, Bill, do you have a general opinion as to whether the state form for power of attorney for finances is a useful form for an attorney to use with their clients?
Everything I said about the power of attorney for healthcare and using the standard form goes out the window when it comes to the power of attorney for finances. I don't like that form. I know some people who, again, I think are great practitioners use it, and arguably for the same reasons, that it's familiar. It's not something that someone might feel that they have to vet closely before they accept. But I just don't, it's almost a tactile thing. I don't like the way the thing looks. I don't think it's clear. My preference is to use the form that I sort of inherited and have been working on continuously through my whole, you pointed out, long practice. So I think it may have its place, but my personal, since you asked for my opinion, I don't like it. So.
I know you want to get to that wild card you mentioned. Can I give you another one from a viewer?
Sure.
Here? Sure. Okay, thanks. So this viewer says the state passed a law in May about remote digital signatures. The viewer was under the impression that all estate planning documents were excluded from that. Can a revocable trust be signed remotely?
That's a good question. I'm not comfortable with that. I don't think the law is clear enough, and I have not had anybody remotely sign a revocable trust. On the other hand, I have, in a pinch, I had someone sign a revocable trust without having all the witnesses present, with the idea that we would follow up and maybe re-execute when everybody was a little more comfortable. But I think you're safer getting a manual signature, even if it's not notarized. And I don't think the electronic signature, it's not clear enough to me that that's going to create a valid document. You got to do what you can do. And if that's maybe the only way you can get something signed, maybe that's better than nothing at all. and hope you can re-execute under other circumstances. But yeah, I'm just not comfortable with even a revocable trust being signed now. So can I do my wild card now?
Yes, I'm sorry.
No, that's fine. This is
one question turned into about 4 or 5, but
No,
I know the viewers appreciate hearing from you on these issues.
for what it's worth. You'll always get my opinion. It's very interesting to me that Wisconsin law recognizes the validity of a will that's executed under the laws of a state where either someone outside of Wisconsin, where someone is either a resident or where they are, as I understand it, at the time of execution or the time of their death. The law of that location addresses the validity of the will. There are states where you can have a holographic handwritten will that's signed by the individual, and that's a valid document. I'm not suggesting you have your clients drive out to, I think it tends to be some of the Western states, go out and do that. But it is interesting that you may have options if you've got people who, say, live or spend time in a couple different jurisdictions. You may be able to forum shop a little bit and come up with a Wisconsin valid will that's signed under the laws of a different state that may be more liberal, or I would submit advanced, about electronic execution or something a little more relaxed than our very traditional, two witnesses in the conscious presence of each other. I think it's an interesting concept. And again, I think this will be less and less of an issue as practice and people get more resigned to functioning in this environment where we're dealing with this disease for as long as we've got it. But that is out there. If it works better in a different state, maybe you have them do that while they're on vacation or something. So again, with another completely abrupt segue, another COVID-related issue is at some point the government's going to need money. And there is an election coming up. And the third consideration is that even if nothing happens in the law, the historically enormous, or enormous by historical standards, I should say, state tax exempt amounts are scheduled to be cut in half in 2026. So it's possible that the current regime, where overnight many of my clients thought they'd never have to worry about an estate tax again, could go away. And we could be dealing with some very significant changes in the estate, gift, and income taxes that bear significantly on estate planning. The estate tax is, of course, a political football, and both political parties love to raise it because it raises money for both political parties. But on the one hand, we have people still talking about estate tax repeal, and we have someone who's running for president who's talking about significantly cutting not only the exempt amount, but eliminating the step up on basis on death, which I would submit is going to be more significant for more people than the change to the exclusion amount. Other things are on the table: eliminating grant or retained annuity trusts, getting rid of the annual gift tax exclusion. Discounting is something that's always up for grabs. And there's even been some talk about getting rid of the practice of using general powers of appointment to increase asset basis, which is interesting. So what do you do in this environment? Well, we do what we've always done. We counsel people that we don't know what's going to happen and that they have some options. There are many people in the, what I'd call the estate and wealth management industry, that are pushing people to do all sorts of things to use these estate and gift tax exclusions now before they go away. This isn't the first time we've seen people trying to rush people into making decisions because it seems like there's going to be a tax benefit at the moment. We do have some comfort from the IRS that if you use these increased exempt amounts to make gifts and later those amounts are cut back, the government is not going to try to claw back exemptions that were available at the time the gifts were made. But these are potentially great things for people as long as they understand that if you make a lifetime gift, it's gone. And if you give away a significant portion of your estate to save taxes, your kids don't have any obligation to give it back. Another area that I think we need to be careful about is there are lots of people pushing Roth IRA conversions because of the change that's already taken place in how fast someone has to take an inherited IRA. But Roth conversions are not appropriate for all or for all IRA holders in all cases. So I think it's an attorney's job to really work through whether that Roth conversion or these other tactics are A, all they're cracked up to be, and B, what the client really wants. The big thing here is flexibility. I'm a huge proponent of disclaimer-based estate plans. A lot of people have come back to me and said, do we still need to have that language in there about the family trust? And for more of them than was the case 6 months ago, I'm saying, yeah, I wouldn't take that out of there yet, because who knows what kind of an environment we could be living in. My next item here, I'm at the bottom of page 6, is whether portability is safe. And I don't mean is it safe from the sense of can you do it? Certainly you can do it. And it's not a bizarre tactic or shady in any way. It's completely appropriate. My question is whether there's any chance it's going to be repealed, which would be an absolute disaster and a poor public policy decision, but anything can happen. But how this bears in this context is as follows. Many of us, consulting with the client, have probably counseled people that no, you don't need to spend the money to file a 706 because you've told me that your estate is never going to exceed $1 million. It's got to be the client's decision, but given that as we look over the horizon, and maybe not so far over the horizon, the exempt amounts that we're dealing with could be significantly reduced, I think it changes the calculation as to whether it's worth the money to file that 706 that you don't have to file. Another thing that I would point out is that there is an opportunity to late file a 706 if the only reason you're doing it is because of portability. And I didn't get this into the materials, but I'm going to give you a revenue procedure. It's 2017-34, and it provides that you have until the second anniversary of a decedent's death to file a 706 to elect portability if the person doesn't otherwise have to file an estate tax return. That is something that somebody comes to you and says, I just lost my spouse, I need to change my will. It behooves you to find out what that person's net worth is and whether there's a huge exempt amount that can be pulled back simply by filing the 706. You also need to point out that portability is only available for decedent's surviving spouse. So you have to get over your awkwardness about mentioning to elderly people that if they remarry, it could have significant estate tax. Next topic.
Hey, Bill.
Yes.
One question. Let's see. I'm trying to. Sorry, I got to pull it up here.
Nope.
Oh, shoot. Okay. Here we go. So the question is, actually, I have a couple of them. The first is, do you notarize the GDPOA and have witnesses as well?
The witness the what?
GDPOA. Is it a power, something about a power of attorney?
Okay.
I don't know what GP is.
My durable power of attorney is, if that's what we're talking about for financial matters, is notarized but not separately witnessed. I think that covers the waterfront. I use the two witnesses without notarization on the power of attorney for health.
Okay, yeah, that must have been what general durable power of attorney,
Right.
GDP.
And that's, yes, no, I don't both notarize and witness that, but I do have it notarized.
Okay, and then one other question. You mentioned portability, and one viewer asks, what is portability?
Oh, sorry. Jump the gun. This is the concept that if you have a married couple, when the first spouse dies, if you file a timely estate tax return, the surviving spouse can take the unused portion of the deceased spouse's estate tax exempt amount. The way we used to do this was by setting up classic AB trust arrangement, where you would fully utilize someone's exemption and put things in the family trust, and then the balance would go to the surviving spouse. So there was no tax in the first death, and you'd minimize the tax in the second death. Now you don't have to fiddle with all that. You can give everything outright to the surviving spouse if that's what people want to do, and you don't suffer any adverse estate tax consequences because the deceased spouse's unused exempt amount is ported to the surviving spouse. Now, for that to apply on the death of the surviving spouse, they cannot have remarried. But that's what portability is, and I'm sorry that I glossed over that. Okay.
You bet.
Okay. Next item, I'm on topic 6. So we're kind of in the stretch, and I've got 15 minutes. An area that we've seen an uptick in claims on is prenups in this context. Couple gets married, they've got a prenup that applies to divorce, and often many years later, the marriage doesn't work out and there's a divorce. And one of the parties says, well, we're going to divide everything based on the terms of this prenup. And the other spouse says, not so fast. I don't think that's enforceable. And I've got this lawyer here who's going to make that argument. And sometimes they win. And guess what happens then? The lawyer who drafted the prenup gets sued, and the lawyer who did the divorce gets sued. So this is just it's a cautionary tale. There's really nothing you can do about this. Some of it is inherent in the nature of marital property agreements, which are not like other contracts. There are many ways to get out of a prenuptial agreement. Some that are completely unforeseeable at the time they're entered into. And that's important to point out to clients at the outset. I recommend when you represent someone who wants a prenup or a marital property agreement that's going to apply in a divorce, that you counsel them that there is no assurance that even if everything is done right, that the agreement will be enforced, because its enforceability depends on court's determination potentially years from now as to whether the agreement is fair at that time. The agreement has to be fair both at the time it's drafted and at the time of the divorce. There's not much we can do about what the future holds for these people, except to draft as well as possible. It's very important to make it clear to the client that the more aggressive they want to get with this, like, I never want to pay any maintenance, and I'm never giving him any of my property, that they run a risk that they're going to end up with an agreement that they can't enforce. And I think every lawyer's got to decide at what point they will say, I'm simply not going to draft an agreement that does that. You better find another lawyer. That's not something any of us like to do, but you can almost count on someone who wants an aggressive agreement that doesn't get enforced coming back at you and blaming you for it not being enforced. What we can control, the substantive terms, again, it's a matter of, it's very situational. Everybody's sort of got to draw their own lines, but what we can control and what we see as an area of vulnerability is the process and the drafting. Obviously, you want to draft a document well. You want to draft it timely so that people have a chance to review it. But you also want to be sure that the personal financial statement is prepared timely and completely. The Achilles heel of a lot of these agreements is adequate financial disclosure. And there are two aspects to that. There's whether the disclosure is adequate. It doesn't have to be perfect. It has to be reasonable, but it has to be delivered timely. Anybody who delivers their personal financial statement to their spouse-to-be the day before the wedding should probably just forget about their marital property agreement, because that is, I think, a potential slam dunk for the agreement getting thrown out and the lawyer being criticized. So we all have this ideal scenario where we draft the agreement months in advance of the deadline because we've been given plenty of time and the financial statement is a thing of beauty and it's delivered to the attorney for the other party way in advance of the wedding, and there's some discussion about the agreements and maybe some hard negotiation, and it gets signed a month before the wedding and everything's great. And how often does that happen? Not often enough for those of us who practice in this area or defend people who practice in this area. People come to you late and you have a threshold decision as to, you can just say, sorry, I can't do a responsible job for you in this much time. I'm not signing on for this. Another big problem is people are told that their spouse-to-be has to get their own lawyer. That doesn't happen soon enough. Those are difficult things that you don't have control over. Some of the things you do have control over are document flow. Ideally, the document would flow from you to the counterparty's lawyer in plenty of time for everything to get done. That doesn't always happen. Sometimes people don't get a lawyer at all, or they're very late doing it. So you've got to decide. My choice is if the other party doesn't have a lawyer yet, you give the agreement to them. Now, you have to be careful because you're dealing with an unrepresented person, and you should probably get that agreement to them with a letter that says, I don't represent you. I represent, the other party to this agreement. I can't advise you on it. Get yourself your own lawyer, please. The thing you run into, though, is your client will say, oh, I'll give it to him or her. You do that? I think you got to think about that and know your client. If you decide to give the agreement to your client, give to the other party, you want to document in writing that that's the arrangement that you have agreed on with the client and that you gave it to them on this date with the expectation that they would, as soon as possible, turn it over to the client. Same thing with the personal financial statements. Some people are very organized and will want to do the financial statement themselves. And I think you should always see it and review it. But I don't think that, unless it's just a condition of your practice, that you have to draft it. But you do want to make sure it's clear who drafted it and, importantly, who's going to deliver it to the other side and when. The other aspect of this is execution of the agreements. Again, you've got the ideal and the real, and the ideal is the parties sit down with their lawyers well in advance of the wedding, and counterparts are exchanged and everybody walks off arm in arm. Rarely happens that way. You run into situations where people have already left town. should they even sign the agreement? Yeah, I guess it's better than nothing, but you may have already failed to manage the situation. Well, sometimes that's beyond your control. One thing to be careful of is, this will happen, is the other lawyer calls you up and says, yeah, the agreement's fine. Just my client's going to come over and the two of them can sign it and we're good. Okay, you've got to be careful. You've got someone who's represented by another attorney in your office. And what if they ask you a question? Your response is, I can't answer that question for you. You need to talk to your own lawyer about it. And you probably want, after the signing, to go back to your office and write a memo that this happened, because you don't want to become an issue in the enforceability of the agreement. My remaining 5 minutes, I'm going to talk about McLeish and what I see as an unfortunate turn of events in the standard of attorney liability to non-clients in Wisconsin. Just to review, the general principle on which I stringently rely in my office is that an attorney is generally not liable for malpractice to someone who's not their client. Unfortunately, and right around the time that I got out of law school, our Supreme Court in its wisdom said, but there's an exception. If you write a will and you fail to see that it was properly executed, or otherwise miscarry in the writing or execution of a will, you can be liable to those who lose out as a result of your failing to bring into being a will that carried out the testator's intent. In 2009, we had a case called Tensfeld, which is very helpful because it said, look, that case that holds attorneys liable in the estate planning context is limited to situations where a document's defectively prepared or executed. If an attorney after the fact gives negligent estate planning advice, there's no recourse for the non-client beneficiaries, even if they were harmed by that advice. And we have used that argument with great effect to get rid of legal malpractice claims in the estate planning context. And there's a very good reason for that decision. It's not just to insulate lawyers from liability, it's to protect the integrity of the estate planning process and the testator's intent. So in 2019, we have McLeish versus Boardman, which held, not surprisingly, but in what my opinion is a unfortunately worded decision, that the ORIC exception extends to claims that an attorney negligently administers an estate. For claim to be made under this area, this theory, the plaintiff has to establish that the attorney's failure to act in accord with the standard of care thwarted the decedent's clear intent. In McLeish, the court looked at the decedent's will to determine what the testator's intent was. Unfortunately for my friends at Boardman, the court found that what they had done was just fine. It's difficult to argue against the premise that an attorney who doesn't administer an estate properly should be liable to somebody. My questions are, why does it have to be the beneficiaries? If you're administering an estate, you should be representing the personal representative. And I submit you should always clarify that you're representing the personal representative. You're not the attorney for the estate, which is kind of an amorphous concept. You are the attorney for the personal representative of that estate. I didn't understand why claim for improper advice related to the administration of an estate can't be brought by the personal representative, who is probably going to be subject to claims from beneficiaries who are disappointed, and they turn around and they talk to the lawyer. I think the most disturbing thing about the McLeish case is that they tried to harmonize this ruling with the Orrick-Ensfield line of cases by tying it to the frustration of the decedent's clear intent. In McLeish, they stopped at the will. I'm wondering what's going to happen when somebody says, oh, but the estate was improperly administered, not because it wasn't consistent with the will, but I can show that the will was not consistent with the testator's clear intent. This, I think, leads to a raft of problems, not the least of which you're getting pretty far away from the idea that we're protecting the integrity of the estate planning process. There is, I think, especially now with current economic situation, a lot of pressure being brought to bear by beneficiaries and would-be beneficiaries to get assets from states. And when they're disappointed, they see the drafting attorney as a target. And I think we're going to be working out the implications of McLeish for years to come. And with that, I'm done.
Bill, thank you very much. I do not see any other questions. And so I want to thank all of you who joined us today and participated in this program, all the questions and the comments. We much appreciate it. And I want to thank Bill Williams and Greg Herman. Bill and Greg, thank you so much for offering and sharing your expertise and knowledge and putting the work in to prepare and get this done for us. We very much appreciate it, as do the viewers. Just a reminder to the viewers, you'll get an evaluation form by email. If you could take a minute or two to fill that out and send it back to us, we would very much appreciate it. That'll do it for this year's WILMIC Summer Seminar. We will be back probably in November for our fall seminar, probably virtual as well, the way things are going. And again, thank you all for joining us online today. Have a great day and a great rest of the week. So long.